Everybody. Okay, I'm going to take roll call. Judge Bigley, Mr. O'Connor, Ms. Innamorato, I'm Judge Ivashevic, Ms. Hallam. Here. Mr. Perkins.
Here.
Mr. Nasser.
Here.
Ms. Griffin. Here. Sorry. Ms. Sear, I apologize. Okay, everybody, we're not going to we're going to defer public comment to the April 1, 24 meeting.
I don't think we can do that.
We can do that.
Not allow public comment at a public meeting?
Correct. We can defer it to the next regular meeting. We're not taking any action tonight. We're not voting on anything tonight. This meeting is going to have to conclude at 5 o'clock because 4 board members at least have to leave at 5 o'clock. So I'm going to ask that we kind of keep things moving. First, I do want to address, I think questions have been raised about who authored these proposed bylaws. So I want to put it right on the table that after the last meeting, I asked Mr. Crum, who's my executive assistant, to draft some proposed bylaws, and he and I went back and forth and revised them and re-revised them, and the bylaws that I circulated were written by Mr. Crum and myself. Okay. I'm sorry. No problem. Okay, so first on our agenda is the bylaws, and what I'm going to propose that we do is just go through section by section, and if anybody has an objection at any particular section, then we can discuss that. So section 1 is just the preamble. Does anybody have an objection to section 1? Okay, yes.
Not a objection, but just with the references we make to the PA state code, if we could just include them as an addendum when we publish the bylaws.
Okay, anybody have a problem with that? All right, then we can do that. And also, I would note that we said the rules are guided by the board's mission statement. I know Ms. Griffin had requested that we have a mission statement. We don't have one yet. So hopefully, I'm sure that we will eventually all agree upon one and adopt one. Okay, section 2. Any objection to section 2? No. Section 3.
Yes.
Go ahead.
I just wanted to talk about Section 3, paragraph F, that says any board member who receives HIPAA, et cetera, information. I'm not sure I would know whether I'm receiving HIPAA information or not. Maybe we could change that to any board member who receives confidential, private, or sensitive information. I'm just worried about not being able to identify when I have HIPAA information or not.
Where are these?
So it's on page 2.
Section 3.
Section 3, paragraph F.
Thank you.
Well, HIPAA is generally known as being medical information. Why don't we say medical, comma, confidential, or other?
Knowingly receives HIPAA? In other words, if we're warned that it's HIPAA, if we're told that it's HIPAA, not to disseminate it.
Yeah.
Well, don't you know when you receive medical information?
No, because you might receive something that isn't HIPAA medical information, but it's still medical information. And so I agree, I also wouldn't necessarily know what is and what
Ms.
isn't.
Griffin's worried that she might do this unknowingly. We could just protect her by saying if somebody shares information with her and says, please don't distribute this, it's HIPAA protected, then she's protected by this.
There's also sometimes a bit of debate on what's HIPAA and what's not HIPAA. So.
Okay, so what do you want it to read? Could you state it again?
Any board member who receives confidential, comma, private, or sensitive information.
Okay, Ms. Innamorato, do you want to say something?
I was just going to add that we should just note that these documents should be marked confidential.
That would be helpful because then we wouldn't have to guess, right?
That all All documents coming from the administration marked confidential should not be shared.
Okay.
And then we should, that will be an expectation that's set.
The only comment I would have about that is how can we be sure that the jail isn't trying to make things confidential that shouldn't be?
Then I think then somebody should raise an objection.
Okay.
Whether or not it's in
Microphone?
No. I don't think anyone from the audience should be responding to anything.
We'd like to hear that, we have a right to hear.
They have a right to hear those, so please put your microphone on.
If you have an objection to whether or not anything is in fact confidential, then you can raise that at the time, but I think that they should be marking things confidential.
Okay, I'm cool with that.
Judge, I did have a couple comments about this. I had about an hour to review it before the meeting, but it seems very broad. You know,
It
I
was
understand.
sent out a couple of days ago, though, too, this same document, I would just say.
Yeah, 2 days ago, yeah. But in any event, yeah, as far as private or sensitive information, I mean, I understand HIPAA, but like, you could argue that anything is sensitive or private. So to the county executive's point, if we're going to specifically designate certain information as confidential and privileged, then it's clear. But otherwise, it's very broad, and, you know, it would arguably address things not even related to my board service, something I look at in, you know, in my capacity as a private attorney, or the judges look at in their capacity as, you know, presiding over cases. So I just think it is too broad as written, and if we're focused on HIPAA information, then it doesn't need to be that broad.
I'm sorry, could you say what you said again? I'm sorry, I didn't hear the first part.
Essentially, I think it's overly broad and not clear what would be referred to as private or sensitive information.
Okay, so I think that everybody would agree that if the information is clearly marked confidential, they can live with that, right?
Yes.
Okay, so I will reword this and send it out for everybody's review before the next meeting, and to that effect.
I have no problem with it written as it is. I think we're overanalyzing small details.
Okay, well, but everybody's good with that, right? Marking it as confidential. Okay, moving on to section 4.
I have multiple issues here.
Okay, go ahead.
So the first thing is I thought that at the last working group, we had agreed to the election of the chair, vice chair, that the one concession we made is that the secretary would stay the controller's office because of many reasons that the controller identified at that meeting. And this, I mean, in general, I want to make a comment first because I feel like this document as a whole is a completely different direction than the document that we had been working on and discussing for months now. So I want to say that first. But specifically in section 4B, where it says the president judge or president judge's designee shall be the chairperson, I thought we had agreed why that is bad practice, especially because the president judge gets a designee. And so I would absolutely like to make that the same as the vice chairperson. And then the second thing would be C. I thought we had agreed on 2-year terms. We thought 1 year was too frequent of a shakeup. And so it says to an annual term, which shall run from January to December. I think that should be 2-year term. And then also under this section, if we go to G, H, about not having verbatim meeting minutes. The verbatim meeting minutes are very important. It is what the incarcerated individuals reference on their tablets to understand what is being talked about in the meetings. It is what we use for accessibility purposes for people who aren't able to attend, and it's also important for purposes of a historical preservation of the record so that folks don't have to go back and watch the recordings of meetings. We actually have those meeting minutes verbatim.
That's provided in G.
I don't see verbatim.
The published transcript. That's what a transcript is.
Okay, so then is H unnecessary and we should get rid of it?
H is just saying that there will also be the text of the motion so that you don't have to go search through a transcript to find when and where was a motion passed. so that you'll be able to quickly and easily identify motions that were passed. It's just in addition to the transcript.
Okay, so then can we add verbatim in somewhere in G or just somewhere to make it clear that we are still expecting verbatim minutes in
That's what a
addition?
transcript means, but if you wanted
The
to say.
published verbatim transcript?
Okay, a transcript, that's what a transcript is, but you can, does anybody object to having verbatim added to transcript?
That's fine.
No? Okay, we'll add verbatim.
Okay, and then B and C, if we could discuss that. I would like the chairperson to be chosen in the same manner as the vice chairperson by a majority vote and 2-year terms. If anybody has a strong argument for 1-year terms, I wouldn't be against that. I just thought that the consensus at the last meeting was 1 year was too frequent of a change-up.
Okay, at the last meeting, I believe that we had a tally and it was kind of tied as to the president judge being the chairperson, is my recollection. And I made the pitch for why I believe the president judge should be the chairperson, because it's a member of the judiciary who is a neutral, non-political person. But does anybody else want to opine on that?
How do they do it in other counties? Is it designated that like a specific person is automatically the chairperson?
Most other boards in Allegheny County, the chairperson is elected in the same manner as the vice chairperson. So this would be a deviation from the common practice in our county. And the statute does not say that the president judge or their designee is the chairperson.
I
it
do
is
not
up to us to
know how
decide.
they do it in jail oversight boards, to answer your specific question. I can't answer that.
But yeah, I would say keep the common practice that we have throughout the county of electing the chairperson, again, especially because of the issues that we have experienced in the past with the designee of the president judge. I think that it should be an elected chairperson.
I understand. I would also say that historically, since the jail oversight board has been in existence, the president judge has been the chairperson in this county.
Well, we have never had a chairperson. We have simply had somebody who ran the meetings. We have
is-
never had a
well, that
chairperson on this board.
Which is
Which is is
functionally
the equivalent of a chairperson.
which has been the chairperson. We just never, I don't know that I think it has been, it's been a chairperson. It's been a de facto chairperson.
And I would argue that that process is what we are trying, the way that things used to be done is what we are trying to resolve
Okay.
with these bylaws.
That's fine. Does anybody else want to opine on that issue?
I don't have a strong view either way. I would vote for Your Honor to be the president, to be the chairperson. So like, to me, like maybe it's a distinction without a difference, but I don't know that it necessarily matters that much.
Okay, well, I mean, we can move on, and at the next meeting, I presume that Ms. Hallam will make a motion to amend Section 4B, and we'll take a vote, because this is the work session to discuss this. How about, does anybody have, I'm sorry.
Oh, that's okay. No, I was just going to mention around point C, I do think doing a reorganization annually is best practice, and we should keep it as written.
Anybody want to comment on the annual or 2-year term? Okay. Section 5.
I mean, this section, I think we have to completely strike. It doesn't even reference Title 61, which every other section does, because it goes in direct contradiction to the state statute that authorizes. It's even in contradiction to our own bylaws when it talks about who's on the board in Section 2, and then it allows somebody to designate, in effect, until written notice of their revocation, a designee on the board that is not allowed by statute. I mean, this is the one, I think, more than anything else in the whole bylaws, we just take out Section 5.
Okay, does anybody else want to opine on Section 5?
The only thing that I will mention is that we are a home rule charter at the county level. And within our home rule, it does allow, it says, under the power and duties of the chief executive, a representative, represent the county or designate a county representative in all meetings and negotiations with heads of other governmental or quasi-governmental bodies. So leaning on that, there is a case to be made how we could appoint a designee in our stead that would allow and act as a voting member. Now, I will say my intention is to attend the meetings, but understanding that life happens, there's other duties. So, this is kind of a safeguard to ensure that we can continue meetings if there's other things that happen in our lives, and we can continue to do the business of the people.
And what I will say, oh, sorry, were you trying to talk? Go ahead. I would,
Yeah, I was going to say, of course, I agree that, life happens, but it also happens to people who are not permitted to send designees. You know what I mean? Even if, we voted on the way that it's written now, the 3 community members will not be permitted to send a designee, and I don't understand why. That creates a power imbalance. I think that creates division amongst the board. We're supposed to be one. It really doesn't make that much sense to me. And of course, it's in contradiction of the statute itself, right? But I think that's why we came with this letter, because, it's an open litigation, as y'all say, you know what I'm saying? And unless I'm wrong, I think I was the only board member who was there, and I heard what the judge said. And she didn't even allude to giving any non-member of the board any type of voting power, you know what I mean? And if you want to do it like that, send a designee forever, you know what I'm saying? I think we should be able to do it too. If not, then we are unequal members of the board, or unequal, whatever one is proper, and I don't think that's right.
Well, it's kind of interesting that you say it's illegal, but it'd be okay if everybody could do it. But
Well,
hang on, because I authored this.
I don't think it's okay at all.
Okay,
But
I
I'm saying
authored
if there
this.
is something that other board members are doing, then the board in its
Okay.
entirety should be able to do it.
Okay, I authored this, and I'm going to tell you my reasoning for it. The 3 public members are designees.
No, they're not.
Ms. Hallam is a designee.
No, they're not.
Okay, so you guys, Judge Bigley is a designee. Judge Bigley's my designee. Ms. Hallam is Mr. Katina's designee. And the 3 public members are Ms. Inamorata's designees. And so you're already designees. In my view, the county executive, the county sheriff, and the county controller, as well as the president judge, have a lot of business to attend to, in particular the county executive. And I know that the audience and this board was extremely frustrated with Rich Fitzgerald's failure to come to a jail oversight board meeting for, I believe he
12
never
years.
came, for 12 years. And I think that
this would allow that
that's
to
the
continue.
root of this, is that everybody wants to prevent what happened with Rich Fitzgerald. But clearly, it's not happening. Like, let's get
Yes.
beyond that. Let's get past that. The county executive has so much business and so many things to attend to that it is really inconceivable to think that she can make every single jail oversight board meeting. It's just
It's once a month.
inconceivable, and it's impractical. Yeah, it's once a month.
Then she just doesn't vote.
Well,
That's it. So I
okay.
will say now, since everyone else has got to say their piece, I would like to say my piece, especially in reference to the home rule charter and whatever it says. State law supersedes the county charter. We cannot have a county charter that supersedes state law. Does everyone agree with that? Does anyone disagree that the county charter cannot supersede state law? Because what you are arguing is that it very much can. And I think that is one of the most basic principles of law, is that the state law supersedes the county law. And even in referencing other state laws, like is done under the preamble, the specific always controls over the general. We have a specific statute that authorizes this board. No county law, no local municipal law, no broad general state law can supersede that. That is basic rules of statutory construction. And so aside from every other argument that I very much agree with, treating the chief executive, the county sheriff, and the county controller different than anyone else, acting as if the citizen members are designees when the word designee is very clear in the statute not to apply to the citizen members. I am a designee. I am the only designee sitting up here, and I and anyone that you would assign as your designee
I believe
would
Judge
be the only
Bigley is a
designee.
designee.
Judge Bigley is not a designee. She is a judge appointed by the president judge. She is an equal member of this board. I am a
You're an
designee.
equal member of the board.
I am a designee. No one else sitting up here right now is a designee. And again, back to the law, because we can all argue, we all have busy lives. I have a busy life. Community members have a busy life, and they're not getting $100,000 a year salaries. Everybody up here has a busy life, and so I do not think it's fair to say that certain members of this board have busier lives than others, and to use that as our argument in favor of this section when we could just point to the law. And the law is very explicit, who is allowed a designee, who is not. We could go back and forth about should they be able to participate in subcommittee meetings, should they be allowed to sit in and listen on those meetings, but when it comes to the duties of this board, we cannot delegate that away and amend by bylaws a state statute.
Okay.
I agree with that, and I do have to add, I do take a little bit of offense to being called a designee, and I don't agree with it. And also, believe it or not, I have 2 jobs, one of which asked me to be in Harrisburg today, and I said I can't because I'm doing this meeting. Because this is so important to me, I have to keep reminding us, right, that it's not really about us. It's about the people who are in the jail whom I represent. You know what I mean? Which is part of the reason why I'm happy to be an appointee on the board, but that doesn't mean I should have, less power, less influence than y'all. Like if I was sick, if I was in Harrisburg, you know what I mean, I wouldn't be able to send somebody in my stead. All right? And y'all saying not only should you be able to send other people on your behalf, but they should be able to vote too. I don't think that makes any sense, especially when at the last meeting when we spoke about this, we said maybe we should wait and see what happens in the courts. And what the courts, or what Judge Emery said was, she was offended, or not even offended. She was disappointed that we punted this to her instead of us resolving it ourselves. But she specifically said, as noted in this letter, that she's not opposed to people coming up and participating in meetings, but they should not have any voting power. You know what I mean? So if we are waiting to see what the judge has to say, I think we should do that. But I do think that, we should not create, power imbalances on a board that's supposed to be equal.
Thank you. Anybody else?
I just want to say, I do agree that this section seems to contradict the statute in allowing it to designees where the statute clearly sets out who can be a designee and who cannot. I'm hopeful that other parts of these bylaws will make it easier for all of our members to participate. As busy as they are, we can change voting meetings, we can change the dates and times by agreements. We can make the meetings run more smoothly and quickly by some of these rules. So I'm hoping that will alleviate some of those concerns of just not having the time to be here.
Thank you. Anybody else?
The only additional comment I had is that I do see the value, especially with subcommittees, that the county executive and, with the people who have busy schedules during the week, to have a representative come to the meetings, a designee who can contribute and do some research and things like that. So I do see value in having people other than just the board members just to get things done. So I do see value in that. I don't know if there's a distinction between voting and participating and things of that nature, but I guess the other thought is it's just kind of like somewhat disappointing that we're arguing about this. It's kind of a legal issue, and maybe it seems like everyone's in good faith coming to the meetings and things like that. So I don't know what the answer is, but I think we can figure this part out. I don't think it should prevent us from getting the work done.
I will agree. I just do not think we should enshrine in our bylaws something that is clearly in violation of state law.
Okay. Thank you. Section 6.
Wait, I'm confused. We're not doing anything in this meeting. We're not coming up with a final draft. I thought we were going to be voting on bylaws at next week's meeting.
We are.
So how can we do that if we are not figuring out what they should look like before Thursday? We're just not going to pass bylaws on Thursday then and push this off
Well,
for another month.
I am assuming that there's going to be amendments made at next week's
I thought that's what
meeting.
this group was for, was to get it in the final state for voting, and then anything that doesn't happen today, there would be amendments.
Well, it seems to me that there are some things that we've agreed upon and some things that we haven't agreed upon.
So shouldn't we agree upon them in this meeting so that the public meeting isn't 5 hours long?
Well, I guess things are either going to pass or they're not.
Right.
So basically what you're saying is the version as you wrote it is what we are voting on Thursday, up or down, and we would have to amend each individual thing from the floor? I mean, that sounds like not great practice. Committee meetings
So
are supposed to be for getting a bill in final state for vote at the full meeting.
So I take it that we're all giving input, and then there will be another draft sent to us early next week. Because we can't vote tonight. We're not allowed
Why
to
can we
do
not? I
that.
thought we sunshine this meeting.
You can't vote at
We
this meeting.
can't vote without public comment.
This
Right.
is not, yeah, so what, at least how I saw it was, we all put in our input. The judge is going to redraft, send something to us next week for a vote on Thursday.
If you remember the last working group meeting that we had, the only reason that we had to do things in that way was because the meeting was not sunshined. And so it was made very explicit and very clear that we would sunshine this meeting so that we did not have the same limitations as we had at the last meeting, and that going forward, these would be committee meetings. I serve on many committees. I know how this works. It's that you get the draft, which is what we were sent yesterday or the day before. You work on it, you figure out what version should go to the full board for a vote at the full meeting.
I don't
It's-
think there's a consensus.
This meeting was sunshined.
But we're not voting at this meeting.
Was this meeting sunshined or not?
Yes, it was, but we can't vote on anything because we have not had public comment. The public has a right to comment on anything that we vote on.
But that's why we wanted them to comment at the beginning of the meeting, and you said no. There was-
Right, because we're not voting.
But we could be.
We're not.
And so are we taking section 5 out for the version that we are voting on Thursday?
No.
No, you can make a motion to amend.
That's either, I don't understand, what would the?
Do you want to take a straw
The issue
vote?
with section 5 is there's no changing anything. I think either people are for it or against it.
Okay.
It's not
Well, no,
like we're gonna
I think
amend
the
it.
issue with section 5 is that it's contrary to the statute. You know what I mean? That's what I think the
But
issue
what
is.
our
I'm saying
whole
though is
bylaws,
it's not
Judge
an
Bigley.
amendment. It's not like we need to amend it. People are either for it or against it.
No,
So
because it's an up or down vote then on the
That's
whole
exactly
bylaws.
what I'm
No,
saying.
No.
But it can either come out or go in.
yes. When,
That's the thing.
But so what you're saying now is that each individual issue that we have with these bylaws will have to be introduced by amendment at next week's meeting.
Right.
We will have to have debate on those issues, public comment on those issues, and we will not have a final draft to vote on then. If we pass bylaws that are
I
in
think it's-
violation, I'm speaking, please. If we pass bylaws that are in violation of the law, our entire bylaws will be void, and we won't be able to use them for anything. Nothing in them.
Someone could strike section.
No, the entire document will be void if we pass bylaws that are in violation of the law. Again,
Okay, well, I disagree.
What's that?
Pass them with the exception of section 5, particularly if we're going to distribute them prior to that.
Right, so that's what I'm asking. Are we taking out section 5 before we vote on them on Thursday?
No. I presume that when we come back on Thursday, you are going to make a motion to delete section 5.
So am I doing that
We
with-
will vote on your motion to delete section 5. If it passes, section 5 will come out.
Well, but wait, not just, regardless of section 5, after this working session, by Monday of next week, or, well, I don't know, holiday tomorrow if people start doing that, but by early next week, there should be a draft of all of our comments that we're giving right now put into a final draft that we can review before taking a final vote or making amendments at the meeting. That's correct,
Yeah,
right?
I agree. Also,
Okay.
it should actually include our input, because we gave input
that-
last time.
yeah, that's what
and
I'm-
It seems
that's
like
what
it
I'm
wasn't
gathering.
included. Also, the public should be aware of what we're voting on, especially if you want them to come up and give public comment about it.
Okay, so again, going back to what I said originally, so every single thing that is up for debate, you want to debate publicly on the floor, line by line amendments, because that is what you're saying right now, is that we're not changing anything that is not unanimously agreed upon. We will be doing that in Thursday's meeting, and I just wanted to make clear that you're ready for that to happen at the public meeting that is already a 3-hour meeting. I don't want people to say, sorry, got to leave early, can't have debate on the bylaws. I will then be introducing 24 amendments to these bylaws because, again, this is not the document we have been working on. You wrote this with your staff, I very much understand that, and completely threw out everything that we have been talking about and working on for months, and now you're saying that we cannot change any of these things?
So wait,
Everything we've been working on for months.
Sorry, Judge, if I could just
Go ahead.
help here. So let's go back to the example on F of confidential. So like something like that
That
will
we
be
unanimously
amended.
agreed upon.
Well, we're not voting on anything, but something that had the input, the judge is going to get that, bring that out to everybody by Tuesday. We'll have that draft by Tuesday for Thursday's meeting. So if there's something that, I object to D, okay, I can make the amendment, or I could say D should be stricken from the record. But there are going to be changes to this based on what we're doing per section.
Yeah, that is exactly what I just said, that the things that we unanimously
I'm
agree
just
upon will be
clarifying.
changed for the draft, and that anything that is not unanimously agreed upon will have to be introduced individually by amendment, discussed individually by amendment, and voted on individually. And I just wanted to make clear that that is the board's intention, because if we are not doing these issues right now, that's what's going to happen in the main public meeting
Well,
next
we're
Thursday.
debating them right now. Everybody, the amendments put on the floor, everybody's speaking their piece.
No.
And no, you haven't spoken your piece?
I did not put an amendment on the floor.
No, you didn't, but you put your position on the floor. You put your position and argued your position, did you not?
Yes, and we're going to have to do that again next
Why
Thursday.
do we have to do it again? Do you need to repeat everything you said? Do you find that necessary?
Yes, because there was nothing done to it. Yes, that's what I'm
Everybody
asking.
knows your position.
Judge, I think, just to clarify, we're all saying the same thing.
Yes.
Okay, so all we're saying is the objections are, what they're saying, there is going to be a new document Tuesday.
I understand.
Is that correct, Judge?
Yes.
Okay, that's I think what you needed to hear, that there's
I
going to
did
be
not need to hear
something
that. I have said that every
But
single
if
time
the
I have
judge
spoken
hasn't
about this.
said that there will be another draft of everybody's input that goes into Tuesday.
She
Well,
did,
that-
but it won't be everybody's input. It
Okay,
will only be a
here's
new
what I will
draft.
do. Here's what I will do. For instance, everybody agreed Section 3F should say that the documents marked confidential. Section 4, everybody did not agree that the president and judge should be the chairperson. So I will put Section 4B, and I will put alternate B. The chairperson shall be elected. So I will put 2 options in there, okay?
That is not
Not
the
what?
best practice for how to do legislating. That is not how
Okay,
this
well,
is done. We
that's how
should
we're
be.
going to do it.
Okay, so we are going to be debating, what is the point of this working session then? Just to find out the things that we all agree on? I don't
Yes,
understand.
yes.
You're going to put alternates? That doesn't make any sense.
Okay, I won't do that.
See,
There'll be a
leave
motion
it.
to amend. I'll leave it. Okay, so we're on to Section 6. Does anybody,
what is the point of this working session? I'm sorry. Is it just to find out what we all agree upon?
Yeah, I think that's what it kind of is. We're
Okay,
kind of
cool.
working, that's what a working session is. We're figuring out what we agree on, what we can have consensus on. We may never agree on some things, and then we'll have a vote on it.
Then I
but
would
we're
ask that we
working on
not
it.
vote on bylaws at the Thursday meeting,
Well-
because we should have time to get bylaws that actually make sense and would not violate the law.
okay, you can make that motion next Thursday. Board liaisons, okay, sorry, Ms. Inamorati.
I'm sorry, just something under section 4H of just identifying how we are going to number our motions so that there's better record keeping. A modification of H. I can write that language.
Do you want to propose a different,
Just to codify name and numbering systems for our motions so that when it's recorded, that you can go back and you can see, oh, 24-001 motion was made by this JOB member. It contained this data, and that way it's better tracked.
okay, so just contain some method by which one can go back and find it.
Yes,
Okay.
so there's consistency in motions, and we don't have to look through unorganized records to
Okay.
find out the business of this board.
All right, before we move past this, I asked a question. I'm not sure if it was answered. Whenever there is a new draft that includes our input, is that going to be available to the public to review and make public comment on?
It has to be, if we're voting on it. But they're only including unanimous input, not everybody's input in the next draft. It's only going to be the things that all of us agree upon.
Well, we could put the bylaws on the website.
But that's a good thing, because then every single person up here will have to vote whether or not they want to break the law or not. And
Okay.
that's
Okay,
cool.
board liaison. Board solicitor. Nothing, okay. ACJ and facility
The only thing I
inspection.
do want to say about section 7D is this clear that, like, I just want to make sure it's clear, the solicitor is never doing anything on behalf of the board without the board's consent. So I don't know if that would go in D, because it says the board shall retain all these rights. But is there anything that we need to add to make sure that the solicitor is never acting on our behalf without approval? Like, I don't see anything in here that talks about the solicitor shall do this at the guidance of the board, or if it takes a majority vote. I know on county council, we have to have a majority vote to get the solicitor to do something.
I agree with that. I think that we should have, we can even do it in the intro paragraph, after authorized approval, which means a majority vote. Do we want a simple majority? Do we want 2/3?
I think simple majority.
Simple majority?
Yeah.
Okay, I think that language should be added in that intro, and then that will clarify the other subpoints.
Okay. All right, section 8.
Yeah, I have many issues with this one, too. So I don't know if this was intentional. I really, really hope not, but it limits the board members to only making one visit a month. I don't think we should punish board members that care to really exercise their duties of the job. So that is in, where is that number? Oh, actually, we should go in order. Let's start with A. Okay, so section 8A, written report within 72 hours. I know a lot of the members of this board have full staff to be able to assist them with that, but I know that the community members do not have staff, and I share a staff with 14 other council members. So the 72 hours, I think, is a little stringent. I would say amend it to maybe be 10 days after their visit, they submit it to the board. But 72 hours, I just know I can't do that.
Okay, anybody agree, what's everybody's thoughts? Anybody care if it's 10 days? Okay, 10 days it is.
And will those be calendar days or working days, business days?
Calendar days to make it easy.
Okay.
And then the next thing is the big issue. I say we just take the sentence out. Individual board members shall not conduct more than one unannounced inspection per month. Again, in violation of the statute, we can go anytime we want.
What's everybody say? Unlimited?
No,
Take out that sentence.
Yeah, I think the statute doesn't place a limit on the ability to go, so.
Okay.
Again, next sentence as well. If the inspection occurs after lockdown, incarcerated individuals shall not be interviewed. Again, contradictory to the statute.
if you're an attorney, you can't go.
We are not attorneys. We are jail oversight board members.
I still don't think, I think it's disruptive, and I don't think that is reasonable. I don't think it should be happening after certain hours. I do think that that's unreasonable.
Did the jail call you and tell you I was going late at night?
No, they did not.
Oh.
I don't know. Why are you so suspicious, like I have some
I just think it's really
relationship with the jail? No.
weird
Nobody
to-
called me or told me. I just know that when there were certain, Rob, you're an attorney. Can you go in during lockdown?
No.
Can you go in during lockdown?
There's various different categories.
You've
of
never been
lockdowns.
able to go in during lockdown, I know, because no one can.
But we can
I
because
don't
the
have-
statute.
But you shouldn't be able to. No, the statute actually reads, Bethany, the board. It doesn't say individual members at all.
It does say the board members shall.
No,
Yes, it does.
No, it says the board.
If a
It does not say
literal-
board members.
A literal
It says
reading of the
the
statute,
board.
the entire board should go together.
Yeah, if you read the statute, I think it actually, the way I read it, I think it actually means the board as a board. I don't think it actually means individual members should be, I don't.
That's what
It
the
says
statute
the
says.
board members shall.
No, the statute, you're reading the
Statute
bylaws.
says the board.
The statute says the board.
It doesn't say board members, it says the board.
The board shall prepare a written report, you're correct.
No,
the
it says the board shall.
The board shall, at least twice each year, conduct an unannounced inspection. It doesn't say board members.
It says the board.
So it is your
board.
position that board members do not have access to the jail
I
unless
didn't
they're
say
with the
that, I'm
full
just
board?
saying, well, you're saying to me about the statute. I'm saying read the statute.
Well, we threw out the statute 2 sections ago, so I don't really think we need
No,
to use
I'm
that as a
just saying,
reference every time.
When you're saying that, I'm just saying it says the board. I'm
Okay.
just saying, I think it anticipates that it means the board as a contingent, like as a whole. I don't think it's talking about individual members going, I don't know whether it does or doesn't.
We have board members who are arguing that they shouldn't even need to come
But I
every
don't
month
think
to
it
the
means
monthly
that we can go
meeting.
down during other periods or that it give us unfettered access at any time, day or night, to go in during lockdown and present some kind of like security risk or any, no, I don't. I
Okay,
don't.
So the
First of all,
lockdown,
let
I
me
would
just
argue, is the
clarify.
most
It
important time that
says-
we need to be there.
It says.
I don't.
If the inspection, I'd like to amend it to say if the inspection occurs during lockdown.
No.
Not after, just during lockdown. Incarcerated individuals shall not be interviewed. You can go in during lockdown, but you cannot interview incarcerated individuals. You're interfering with the operation of the jail and the safety of the jail. They have lockdown for a reason.
All right, my issue with that is they were recently locked down for like 4 days. And the reason was not related to anything that they did. Quite often it's locked down because they say they don't have enough staff. Last time they were locked down, they said because there was an issue with their tracking system. All right, so for the 4 days, my beef is, that it limits our ability to respond to emergent situations, you know what I'm saying? And, again, I don't really think it makes sense to limit our ability and our power at all, especially if our concern is supposed to be the people who we are interviewing. We should have access to them, you know what I mean? And, the last time we went, I'm sorry, by show of hands, who on the board has been to the jail and done? Well, I'm very, very happy to see that. Very happy to see that. No doubt, no doubt. I am certain that, the other board didn't go, the previous board didn't go. I am concerned if all of us have to go at the same time, it will never happen. You know what I'm saying? But basically, like nullifying our power and our influence as board members. You know what I mean? And I don't really think that. I really don't think it makes any sense at all. And if we care about the statute, we should care about it in its entirety, you know what I mean? Especially when we're talking about designees, which I think is the main issue, as opposed to like the board's function of actually going in and making sure that everything is operating the way that it should be.
Ms. Innamorato?
Thank you, Judge. I think that, we should not have a literal interpretation of state statute and provide that flexibility and allow for individual board members to go. And we should clearly state that in our bylaws and clarify that it is board members. So I believe that we should add that clarification in. I also believe in Section A, between individual board members on down, the whole section, I do think that does hamper our investigatory power that we have as board members. But I think having something like just a statement that, these inspections shall be, the last part, shall be reasonable in scope and duration, like that should suffice. That should allow for flexibility that wouldn't hamper the investigatory powers of the members of this board. It clarifies that individuals can go into the jail, and it just gives some. I think that limiting it in our bylaws is hampering our ability to do what we're tasked with doing.
I agree, and I would just take out that sentence, if the inspection occurs, and keep the last sentence that says, yeah, it should be reasonable. We shouldn't be putting ourselves in danger, incarcerated individuals, the jail and, staff in danger. We should be reasonable about our inspections.
Okay.
Including,
Let
they
me
should be
just
tough but
say-
reasonable.
Okay. Bethany and Manny have gone to the jail February 6, 6:20 p.m. to 9:55 p.m., February 27, 7:45 p.m. to 11:10 p.m., March 12, 6:39 p.m. to 10:50 p.m., March 27, 7:45 to 11:30 p.m. Nightly lockdown is 7:45 p.m. So all of those 4 visits, they've been interviewing people after the nightly lockdown, which is extremely disruptive because everybody's in bed for the night. Every visit involves yanking people out of bed and after the lockdown, which I think is disruptive to the operations and safety of the jail.
So I would
That's
like to say
where
something. So
this
first of
is
all, I
coming from.
wasn't making it up. You did have a record of every time I go to the jail, and that's great because I would like to know who else from the board went during that same time frame to do an unannounced inspection of the jail.
I don't know.
Right, so we are exercising our duties as board members and taking it very seriously. We have full-time jobs that we cannot leave work to go to the jail. So nothing in the statute allows our access to the jail to be hindered. I think that even leaving reasonable allows the jail to say it's after count that's unreasonable. When no one else can go into the jail, no visits, no lawyers, anything else, we as board members are the only people who are able to. Limiting that in any way, we are never disruptive. And what I will tell you will happen is exactly what happened to me for the past 4 years, is every time I'd go to the jail, up until very, very, very recently, I would have to sit and wait for at least an hour, sit in the entryway to the jail and wait for them to allow me access because they said that that was something they were allowed to do, that was reasonable. Under Warden Beatty's leadership, that has stopped, and I now no longer have had to do that for the past couple months, and I appreciate that very much because it is very important that when no one else has access to the jail, the Oversight Board does. And so even saying shall be reasonable in scope, it sounds to me, and correct me if I'm wrong, like you're saying that those times are unreasonable. And so that would be limiting when we can access the jail.
I'm not saying that the times are unreasonable. I'm saying that interviewing inmates when it's supposed to be during lockdown, I think can be a safety concern. That is what I'm saying. You can visit the
We go to their
jail
cell
at
doors. They
3
stay
a.m.
locked in their cell. There's no safety concern. We scream through the door, through a steel door to talk to them most of the time. I don't see the safety concern that exists by, if I wanted to go to jail at 3 in the morning, I could do that.
Yes, I agree.
Right. And I could
agree.
talk to people. I wouldn't because I'm not a jerk, so I'm not screaming at people when I know that people are sleeping. But I can tell you that we cannot limit our access as board members to the jail, especially we're allowing all these other things too in violation of the statute. Never has it ever been in dispute when board members can go to the jail. And I believe the statute says that very explicitly for a reason.
And nobody's trying to limit when you can go.
I mean, it literally says you can't do it more than once a month. You can't do it
That's-
after a
that's
lockdown.
out.
You can't interfere with the normal operations of the facility, and it shall be reasonable in scope and duration. If I want to go for 24 hours, I can go for 24 hours. And the scope, we have access to everything. The statute is very clear about what we can see. I think we take out from individual board members down to the end of that paragraph.
Do you agree that we could keep in shall be reasonable in scope and duration?
No, because I have seen that misused. I have seen them say previously, when that wasn't even codified into bylaws, what's reasonable? Do you think it's unreasonable that we go during a lockdown when, oh, we don't have staff and that's why the jail's on a lockdown? Well, all the more reason why we need to get in there during that time. Or if we go in the evening, I want to see when the Ramadan meals are passed late at night. I want to be able to talk to people at the end of their day, see how they're feeling from the Suboxone that they haven't gotten in almost 24 hours now, see how their day has gone, see if they got access to something that they were promised to a week ago, talk to the night shift supervisors who don't come on till 11 o'clock. Those are all things that need to happen at different times of the day, and I am very worried that saying reasonable is a very very ambiguous term, and it will be construed in a way that limits our access as board members.
But I do think the things that you described are reasonable and reasons to go into the
But
jail.
different county executives and different wardens could argue otherwise, because reasonable is such an ambiguous term. And again, I do believe the statute, you had it in front of you, Judge, if I could, I don't have it in front of me. Do you have the statute somewhere? It talks about our access to the jail. I can pull it up.
It just says, during the inspection, the board shall interview a cross-section of inmates out of the presence of the warden and his agents to determine the conditions within the prison and alternative housing facilities.
Right.
So on that note, thank you for reading all of the times that we've been to the jail. That's something I actually take pride in. The day that I was voted in officially, we went to the jail immediately after, and hopefully, we can continue to do so unfettered. But we have a list of folks that we want to see, mainly given to us by family members or community members, and we never get through the entire list. All right. Every time we go, for however long we go, 4 hours, maybe 5, we don't even get through, everybody that we want to talk to. All right. I think that speaks to the need for us to be there, but I also think that speaks to, that term or that word unreasonable being misconstrued or being interpreted in any way. Maybe you don't think that's reasonable for us to be there for 4 hours. I don't think it's reasonable for us to wait for an hour until, we get somebody to escort us, you know what I mean?
Well, I agree with that.
But I think again, to reiterate, the reason that we're here is for the safety, the well-being of the people who are in there. You know what I mean? And, Bethany talked about how we're not really interfering with the operations of the jail, and we scream at the incarcerated people through the door. And the last time we were there, I believe it was yesterday, I was screaming at my nephew, you know what I mean, through the door, who was locked out, who wasn't asleep, even though we were there, what you may consider to be late at night. So I don't think we should put anything in here, first off, that contradicts the statute. Secondly, that limits our power and ability.
Mr. Namarata?
Thank you. What if the JOB defines what is reasonable within the bylaws? So if we have shall be reasonable in scope and duration as defined by the Jail Oversight Board. That way, you're not putting it on the administration to say, you can't come in here because we deem this unreasonable.
Right,
So it's something that we're just setting an expectation for ourselves, and it's not something that could be used by the administration.
Right, but I would still be worried that this board would try to limit it further than the scope of the statute. And again, I want to just quote from the statute. I pulled it up. It says, the board shall, at least twice a year, conduct an unannounced inspection of the prison's physical plant. During such inspections, the board shall interview a cross-section of inmates out of the presence of the warden and his agents to determine the conditions. And then we write the written report. And then again, further down, the board shall investigate the conditions, the books, papers, and records of the prison, including but not limited to the papers and records of the warden and those relating to individual inmates, shall at all times be available by inspection of the board. So I know we have talked about that subsection in relates to like us getting the policies and procedures before, but here it very clearly says at all times everything of the jail should be available to us, not when it's reasonable to the administration or to individual members of the Jail Oversight Board, not when it's convenient, not when it's daylight, not when it's a weekday. There is no limit to be placed on our access to the jail as board members because we are the oversight. How can we be oversight if we can only be it during certain hours?
Okay, well, I think we agreed. We're going to strike the restriction of one unannounced visit a month. We're going to strike the next sentence about lockdown. So now we're down to the very last sentence. Right?
And again, I believe that it is
understand your position.
too ambiguous to be codified.
Okay. Can we leave it, inspection shall not interfere with the normal operations of the facility? Period. How about that? Okay.
And then the reports within 10 days, we were changing.
10 days.
We have that.
Okay, done. Moving on to B. Any objections to B?
I think that we can do, it says within 72 hours, the warden should provide
10 days?
I would say, no, I was going to say 24 hours.
Okay.
That's to shorten the time.
Oh, I absolutely think that they can, this goes back to the same thing. They have to give us access. They cannot deny us access. They could write a letter every day according to these bylaws saying, no, you can't come, and nothing stops them from doing it. They use safety and security for everything, and we've learned that that means understaffing to them. The jail is always understaffed. So according to this B, they could at all times deny us access. I think we just take out B.
Well, I think that, there are times where you've gone and you've expressed frustration because you've had to wait for an incredibly long time to get in and to, be able to conduct the inspection and the interviews. Like, in that circumstance, I think the warden should be responsible for reporting back of why it took so long for you to get access as a jail oversight board member. And this creates an expectation of the warden to be able to provide that.
But it allows, so you're
information.
saying take out the denial or denied? Because this right now says that they can deny us access.
I don't read it that way. I read it as if they should, for some reason should they do it, they have to tell us why, but not that it gives them permission to deny.
So then can we take out or denied and leave the rest? If what you're saying is when I have to wait an hour, they should have to explain why.
Yes.
Then that still happens if you take out or denied. I
If there
think,
is,
Read it
No,
as
but if they
giving you I don't read it at all as ever giving them the right to deny you. It just says that in the event that
They should unlawfully do that. They tell
they
us
have to
why.
tell you
I mean,
why.
let's just say.
But they're
there's a
allowed as long
bomb
as they
threat.
write it
Let's
to
say
us.
there's
No,
some
it's
bomb
not.
threat down
They're
there.
not
and they
giving
say
them the
you
right to
can't come
deny
in.
it.
It would be some extraordinary circumstance.
Because the first sentence says they're not to inhibit your access to the jail
Yeah.
or housing facility. That's the first sentence.
Then they shouldn't be able to deny us access at all.
That's what
They
it says in the
shouldn't.
first
Right,
sentence.
but in the other sentence, it says, if they deny us access, they have to explain why,
Right,
Exactly.
which they shouldn't do it at all.
right.
So it
Exactly.
shouldn't be in there.
but there may be a circumstance that arises
event
where
that it does
if
happen,
they
they have
ever
to
deny
explain
a
why.
board member access, if they ever delay access, they need to provide in written form to the board on why they did that within 24 hours.
Do you see why that's contradictory?
No.
You're saying they will
No.
never deny you, but if they do, they have to give us a reason.
Yes.
Yes.
Because things happen.
So they will sometimes deny us.
No.
Because things happen. I mean, am I like
Listen,
hearing
you
the same
just
stuff
said
everybody
that
else
You
is?
used to have to wait an hour, okay?
Yes.
We're saying we don't like
Okay,
that.
then you know what?
So
Why
if
don't we
they
just take
try
that
and make you
whole-
wait
you know
an
what?
hour,
Strike
they
the
need
whole
to
paragraph
provide an
and forget it.
explanation in writing to the board within 24 hours. Why did they make you
For
wait an
delay,
hour?
I've never been denied. Why is denied in
Well,
here?
let's say I gave the example of what if there's a bomb threat and they say you can't come in here?
Is everyone else out of there? Because if everyone else is still in there, why
You know
can't I
what?
go in?
I say strike that whole paragraph. Just strike the whole
Sure.
paragraph.
Cool.
Strike it.
Agree.
I think it should be in there.
I mean,
think
it's
it
a
should be in there
protection
with
for-
denied. Yes, if they should deny, they should tell us
can't
why.
deny.
But they might, so they're going to tell
Okay,
us.
let's move on. We don't have a consensus. Committees.
This board is worse than the last one already, man. This is wild. At least they didn't try to codify breaking the law.
That's your opinion. That's your
That is my
opinion.
opinion for the record.
Yes.
As someone who
Committees.
sat on both boards.
Committees. Anybody have anything? Okay. Warden. Warden reports.
You have something about warden reports.
Judge, with respect to the committees, it says 3 members per subcommittee. Is that to keep it an odd number as opposed to 4?
Yes.
Okay.
And on subsection G, a board member shall not serve on more than 2 committees. Why not? If somebody wants to work on all the committees and the chair allows them, why not let them? We've already given the chair which again, I will dispute more of the committees
The
if,
chair is not going to appoint members to committees anymore. There's going to be a,
appointment committee.
Yeah.
I see that. And who picks the appointment committee?
well, the chair does, yes.
Right. So the chair is picking who appoints people to all the other committees. and the chair is allegedly not going to even be elected. And now, only a board member can only serve on 2 committees. I'd like to be on all of
To give
them.
a chance to every board member to serve on committees.
Okay, and wouldn't it be better to just expand the number of people on committees as opposed to limiting the number of committees that a board member who
Well, you
wants to
can't-
be involved can be on?
You can't have 5, and you need an odd number. If you have 5,
We have a quorum.
right.
I
So you
understand
have
that.
to have less than 5.
Uh-huh.
And it would be better to have 3 than 4, because if you have 4, you're going to have a tie.
I don't dispute any of that, so then can we take out G?
Well, what's everybody say?
If the,
I noticed in the previous board, they had pretty specialized subcommittees, like book committee and things like that. So if you have 15 committees, then, you know, it's not unreasonable to be on more than 2. But if we're going to have like broad committees, like health and safety, then that covers a lot of different things. And then it's more reasonable to have, you know, a 2 limit. But I think we don't, it's kind of hard to say, we don't know.
Depends on how many committees. I don't know how many committees we'll have. What's everybody's pleasure?
I don't think we have any official committees right now because they have not, we don't have a chairperson.
We have we have one committee.
Check how many we have. Well, I'm just.
What's the committee?
The one we established last month.
The healthcare
Yes, the
advisory?
healthcare.
And who's on that?
Nobody.
So we don't really have a committee.
Well, we established the committee.
I thought we had
but
an autism one.
We used to have a suicide prevention subcommittee, book subcommittee.
Bylaws, exit interviews, suicide prevention, IIW, books, and health and services. So 6 committees as of right now.
Okay, you want to make it 4?
I feel fine striking G because
Okay.
we have an appointment committee, so.
Okay,
But I also, unless we want to say something like, no board member should, like, I think that there's a, being designated and leading a committee, that's one thing, but I think that every board member should have access to every committee. And if we want to clarify that every board member will have access to all committee meetings.
but you can't have a quorum is the problem.
Oh, that's true. That's right. That's why we were doing that.
It's limited to 4.
Limit if the committee's gonna appoint. I don't know that you need to limit maybe.
Yeah.
Agree. Take it out? Okay,
Committee that'll make sure it's balanced.
okay, it's out. Anything else in section 9? Section 10? Section 11?
That was, wait, where's section 10? It's not in here.
10 is just the warden.
No, it's 11.
10's the
There's a text
warden.
on the one we have.
11.
I sent out another one.
9 to 11.
No.
And some
I
copy.
sent out another one
Oh,
today,
sorry.
because I said okay, warden reports.
Yeah, I have a couple things here. Let me figure out what number this is. The Warden Schmidt. Dun, dun, dun. No later than 7 days before the next meeting. All of these things are the things that we get already. I just wanted to clarify, is F the thing that the population breakdown of like detainers and all that? Or is this just how many people have come into the jail? You know that sheet that we get that says like how many people are serving sentences, how many people are on detainers? What did they call
Well, what's
that?
F?
That was information provided by other source documents, including.
Encore, you wrote a letter which had a proposed warden's report. Do you remember? And that's where Will pulled a lot of this.
Are you referring to 3F?
Yeah.
Yes,
State population statistics
yeah.
report? I think that refers to the report that comes from
The court.
the courts. Yes, that's the ACJ and alternative housing population statistics summary.
Does it include
I'm sorry to interrupt.
That's okay.
The board itself raised this issue that meeting regarding the delay time from intake through release. So there's a basis from the transcript that this board had an issue with not having information
Yeah.
about those statistics. It was incorporated in conjunction with what Encore just stated.
This was the time from when they get the 6A to when they actually release the person.
That is correct.
Okay.
That's what you mean by intake population statistics?
That is a
That doesn't make
broader
sense.
term, indeed, and that's where it indicates including time to release. So it is a general statement that provides the board the power to ask for intake population statistic reports, including the time to release statistical information. If someone with better institutional knowledge amongst the board members wants to define with more specificity the terminology for that which I, as a layperson, understand as intake population, I welcome you as a board to do it.
Where'd Kelly go? Rob, what would you say? We could make that G and say, what would we call that?
It could be within F, but you have the jail population dashboard that DHS does, but kind of have an understanding of holding status and things of that nature. And then the jail has a new diversion program where they're getting people inpatient beds for mental health treatment, substance use treatment. Those are the types of things that we can look at to understand kind of the day-to-day population in the jail and also opportunities to perhaps get people out of jail and into treatment programs.
You know, but like F deals with intake, and that second part of it, including, really deals with release. It's not really intake information. Do you
No, that's
follow
fair.
me?
Yeah. Jail population status?
I'll figure it out, okay? But I'm going to separate it into two different things. And G is going to be time from receipt of 6A to actual release.
Okay, the other information that the jail has agreed to give us that was not included in here is when the jail requests because of medical reasons that the court 6A release, they had agreed to give us that, but that is not listed in here. So can we include that?
Yes.
Also, overdose numbers. And then lockdowns.
Okay, what do you mean by overdose?
How many overdoses happened in the jail in the past month? And
They
that,
do provide lockdowns right now, right? I mean, they provide that.
but not ahead of the monthly meeting. We do not always get that because the law that dictates that, Chapter 205, requires it to be done by the 7th day of the month. And often our meetings are before, so we might get a lockdown report a day after our meeting, and then we have to wait a whole month to address any of the issues from it. So I think lockdown reports, overdoses, and again, I think we should be very clear that we just want like numbers, maybe. If they want to, it would be nice to know how many are happening in intake, how many are happening in other places in the jail. But I want to be clear that we're not asking for like people's names who overdosed. So yeah, lockdowns, overdoses. I forget how you phrased it when you asked the jail about it, but the 6A releases that were for medical reasons.
I remember.
Yeah, however you did that. And then what's the other thing? There was one more thing. Oh, hospitalizations. And a hospitalization report, like you would get when you file a right to know request for ambulance trips, it would say, like, for example, hospital on this day, hospital run on this day for suspected heart attack, suspected overdose. It gives like a kind of detailed, I think they call it the ambulance log. I don't know if Encore or Corey or somebody, you remember what they call that document that's like the ambulance logs? Is that the word, the ambulance logs? Yeah, ambulance
So
logs.
just ask for the ambulance law.
Ambulance logs, yeah. And you can even
Okay.
say with PII redacted so that we don't get anybody's name.
Okay. Anything else?
With respect to the lockdowns, do we want to be more specific about asking for more detailed reasons as to why we have lockdowns?
Yeah, I like that.
Yeah, I like it too, because
Like, for example, when we went yesterday, it was locked down for 2 days because, not even because of staffing, but because the OMS system was down. Other times it's locked down because of staffing. Other times maybe it's locked down, there's a suspected escape. Saying safety and security doesn't give us much information.
Okay, all right, I'll revise this and get it out to you guys. Anything else?
I had something else on this. Sorry. Somebody else talking, or was that me? Are we still on number 3, or are we just doing this section as a whole right now?
As a whole.
Okay, so you have the additions for number 3, and then I'm going to I really like number 5, but going to number 6, it says, upon receipt of a monthly warden's report, the board secretary shall have the power to issue a notice to attend upon the warden, deputy warden, or identified requested designee. And I just didn't really understand what that means. Is that so that we can get like the nutritionist here, so we can get the Suboxone doctor here, so we can get, is that what that means?
Yeah, to get anybody we want here to answer our questions. I mean, really, though, the warden has to come anyway, so that's kind of...
Can we maybe outline that here, that the warden has to come? Because I could interpret this to mean that they can issue a notice to attend to the warden, deputy warden, or a designee for either of those positions.
Upon unidentified requested designee, because it goes without saying that the warden, deputy warden have to be here. So why don't I strike the warden, deputy warden, and just say, issue a notice to attend upon unidentified requested.
Or any other requested designee.
Or just, yeah, okay, yes.
In case there's someone else you want to bring in.
So basically, I don't know what I want the words to be.
There's other, like that CRNP.
Upon receipt of an NWR, board secretary shall be required to issue a notice to attend upon unidentified. Okay, so we can see, the warden and deputy warden have to be here, but if we want to request somebody else come.
So we could just say
We're just-
any other request.
Yeah, we're going to strike the warden and deputy warden because they already have to come. We don't need to serve a subpoena on them. Okay, you guys with me?
Yeah.
So it's just going to say, we can issue a notice to attend upon unidentified requested designee, whoever we decide. Yes, Will. Okay. Anybody else?
I do have just a question about like how we compel them to attend, like what if they don't?
We'll send the sheriff to get them.
Okay, can we put that in here?
I don't think we necessarily need to. It's not like they're reading it.
Right, but I'm just,
It's not like the unidentified person is reading it is going to be intimidated by it right now.
but I mean, just for purposes of
Maybe it
like,
should be a subpoena.
But it says right here that shall be governed by the format set forth in the rules of civil procedure.
so can we put that then?
Okay, hang
The
on.
board secretary.
Let's put that it shall be a subpoena
Yes,
instead of a notice to attend.
yes, love that.
And like I said, it's spelled right out. It says governed by the rules of civil procedure, 234.3. So maybe just have to read that.
Well, we might need to change the rule of civil procedure
Yeah.
if we're changing it to a subpoena.
Yeah, and it's also
Will you
talking about
take care of that, please?
The warden or warden's representative. It still says in subsection A, the notice to attend may be
Okay,
issued
so
via
it'll be
email.
issued to the designee.
Yeah, we don't need to compel the attendance of the warden or their representative to provide information because he has to. I mean, I would love to subpoena the warden if he ever tried to not come, but that,
Your Honor, I'm hesitant to interject. It's not my-
Go ahead.
But the extent that infers that the board has the power to subpoena, which I am not going to weigh in on.
Yeah. What I'm saying
Is they don't, but as the secretary, in my role, I can, as the controller. So if you just leave it as board secretary, it's me anyways,
Okay.
or my office anyways.
So to clarify, it would say, upon receipt of a monthly warden's report, the board secretary shall
Have the power
to issue a subpoena upon an unidentified requested designee to thereby appear before the board at the next regularly scheduled meeting date to answer questions related to the monthly warden's report or issues raised by the board. Yes?
Yes.
Or are you saying that, just if we can, so what you're saying is by law, it shouldn't say that the board can do it, but I know that I can. Is that, you're saying that it shouldn't be in here because the board can't actually do that, but my duties as controller, I can?
And whether
So
your
you're-
role as controller extends to the board to issue subpoenas.
Right, okay. Why don't we just work on that? Well, I get what you're saying. We'll work on how to do it, but I mean, I know that I can do that. So
Okay.
why don't we just try to figure out how you would phrase that?
And then just make sure that we rephrase A as well when we do whatever we do to 6. Make sure 6A is also rephrased in accordance with whatever 6 changes to.
If I may interject, if I'm out of order, just tell me.
Go ahead, Will.
There will be instances where perhaps the board does not know who the specific person is who has the knowledge about particular substances, statistics, and that you may just say, be issuing a subpoena or notice to attend whatever vehicle you want to use, where you might have to identify the person with the most knowledge of subject matter A or B. And that's why the reference to the rule of civil procedure, because it permits that. And the prudence was not to weigh in on at this point about subpoenas and whether the board has subpoena power. So I don't give a legal opinion in that regard. I'm just presenting something of prudence at this point. Because the board may not know who it wants to subpoena, but it is, as designated in the language, look, Mr. Warden or Miss Warden, if you don't have the information, you have to be here, but you better bring that person with you who does.
Okay.
That's the reason, that's why the language is.
So maybe we ought to keep it the way it is.
The controller does.
You could have hypothetically a warden who doesn't know a dime about a nickel, but you want the person who has knowledge of the nickel.
Okay. Okay, anything else in Warden's report?
Could those interjecting or being consulted by the board please identify themselves just for those following along?
My name is William Crum, C-R-U-M. I'm the executive assistant to the president judge, and I'm also a licensed attorney in the Commonwealth of Pennsylvania. I've been licensed since 1985.
Very nice.
That was a nice intro.
Anybody, anything else? How about under annual report, anybody?
In addition to the Warden's report, 14.
The only thing I would note about the annual report is that it's a new requirement. So it's just a new requirement, like we're manifesting under these bylaws.
Just in paragraph 2, I think there's a wording, I think maybe we meant compilation, yearly compilation.
Instead of capitalization.
I'm sorry. I don't know.
Or whoever drafted this, I think that's a new section, new sentence. The warden, the annual report should contain a yearly compilation. That's all, just a word change. I think that's what it was meant to be. We could have a capitulation if that's what they want to do, but
That's why it wasn't funny to me, because I didn't know what the word meant.
You'll find that that's your discretion, but a secondary meaning of capitulation means to reiterate, to capitulate
Okay.
what the information was.
okay.
The grammar or use of language is your discretion.
Okay, board meetings in the public. You do?
I'm gonna let other people go first. I don't want to talk too much.
Anybody have anything?
Yeah, we have a few issues with it.
Go ahead.
Yeah. All right, so the one that says time for public testimony should be afforded during each public meeting. Person speaking before the board should deliver testimony during the public comment portion and have to sign up before. It says the board in January voted to give speakers up until public comment to begin sign up. I guess I have like comments about public comment in general. Of course, like, the meetings start at 4. Normal working hours are 9 to 5 already. People are disenfranchised. We don't often take into account people who have disabilities who can't make it to the meeting. I know every time when I was coming to give public comment,
I think he's on subsection B of section 13, public participation.
Yeah, but I don't know which section we're commenting on. Love it. What number?
13.
Okay, thank you.
yeah, but just in general, I don't think we should agree to anything that limits the public's ability to participate, especially because they're impacted by the jail at large. And so, if we can, I think we should, or like the board voted to in January, give speakers up until public comments to begin signing up.
Okay, so Manny is saying B3 says you have to sign up to speak prior to the commencement of the meeting. Manny's saying change that to say sign up to speak before the before that section. I can't remember. Public comment starts. What's everybody's pleasure?
Could we change it to before public comment ends? Because we're not going to reopen public comments for you, but as long as you're here before we finish the public comment section.
My only problem is that public comment takes so long. It takes like 2/3 of our meeting. We never have any time to do anything. That's my personal comment.
I think there should be a point where it is cut off so that we know how much time we have to get to business. I think maybe it should be cut off and say the meeting starts at 4 o'clock, maybe till 4:20 or 4:30.
Or 5.
But it shouldn't go to 5 o'clock. I mean, there has to be a point where we know that we have an end and we can say that we're going to be reasonably starting to get to business. I mean, we have to.
Ms. Innamorato.
Thank you, Judge. I think that there's a way that we could allow for people to sign up before the meeting without having to physically be present. This is common practice in many other boards. I don't know if we want to put that in here because we do list websites where people can get information where it should be listed. We could create a sign up where people could sign up until 24 hours before the meeting online, and then keep until the beginning of public comment if they're in person.
Yeah, what if we do both?
So we could do both. I think that's easy to do. I don't, there shouldn't be a long turnaround time to do that, but if the folks are willing to entertain people registering online because they're allowed to submit public comment online, they should be able to register. That's a simple enough technological fix.
So you're saying do online public comment,
You could
and as long as they are in person, and additionally, you can sign up in person prior to the commencement of public comment instead of the meeting?
Yes.
Okay.
I think that would be confusing is who was in line first. Do you know what I mean? People are going to be like, well, I signed up online.
Well, we would get that list of online before the meeting starts because it closes at 24 hours before the meeting. So anybody who signs up online would be before anybody who signs up in person.
So I guess.
So if you want to speak early, sign up online.
Not necessarily know. Like, I guess since you're calling out the names.
So basically, okay, sorry, I'm thinking aloud.
Okay, so they may sign up online and/or in person by what time?
I think you actually distinguish. So at council, what we do is you have to sign up online but for 24 hours before the meeting starts. So it would be by 4 p.m. Wednesday if you want to sign up online. In person, I think we just change meeting to public comment.
Well, who's going to get this sign-up sheet online at
The
4
secretary of the
p.m.?
board.
I think we can figure out how to operationalize that.
Online, do not sign up, don't sign it. You know, like if you signed up online, they get here, don't sign in. We already have it.
So, I mean, the public comment goes to the court, so I'm sure there's just a way to add something. I mean, it's more like a technology thing to just get a list from them. We'll collect the ones that are outside like we always do. I think that would be, when you submit your public comment, there should also be something on that site that says, or instead of writing it and you're going to be here, that's when you would sign up for it.
Okay, Mr. O'Connor, we'll do it.
I'm not saying that we need
I'm
somebody.
only kidding. Okay, and then are we having an in-person cutoff time
I think 2 months.
Then I say we cut it off when it starts, because we already.
when public comments start? Okay. Okay, anything else?
Yeah, and B3, unless I'm wrong, I think it says, time for public testimony shall be afforded during each public meeting, blah, 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 blah. Are these working meetings also included as a public meeting?
Yeah.
Well, generally speaking, no, because as in today, we don't take action at working meetings. So, no. This is so that we can accomplish some work.
We're taking lots of
I
action.
got you, but I just don't understand it because,
Here's the thing, if you don't mind saying. As it is, we do this, you were saying, Bethany, we're getting a lot of stuff done. Here's the thing, the reason for doing this is because we're getting very little done at the public meeting. So if we do that at these meetings, then there's no point in coming to these meetings. Right? Because we're spending hours, 3 hours sometimes, on that portion of the public meetings.
If-
So if that's what these are going to turn into, then no.
So again, I want to refer back to the law, the Sunshine Act specifically, that says that there are exceptions to the Sunshine where we can be in executive session doing things, but when we are having public meetings and we are debating issues in front of the board, it has to allow for public comment. It has to be sunshined and advertised. It is very explicit on what we cannot allow public comments on and what we can. Yeah, I mean, again, our committee meetings on council are very much what I equate this to. It's where you get the work done on the legislation that is in front of you. Those absolutely have to allow for public comment, have to be sunshined, all of those things. So again, I don't have the Sunshine Act in front of me.
Well, I do, and we can defer comment to the next public meeting.
but this is also a public meeting. It was put up on the website 24 hours in advance. The agenda was published in advance, the same way that we do our regularly monthly meetings. So I don't understand why the public speakers are disenfranchised.
Because we need to accomplish some work. That's why.
But we can't bypass the Sunshine Act for that. This is a public
We're
meeting.
allowed to defer public comment to the next meeting.
To the next public meeting, not the next regular board meeting. The
Yes.
next public meeting, this is a public meeting. So if you would have,
deferring comment today until the next meeting. If you,
so you're going to, but you're saying with every meeting, that's what we're going to do?
no, we're going to have public comment on Thursday. This is a work session. We're not having public comment.
But it is a public meeting.
Yes, it is.
Right.
Yes, but
And we are
don't have
debating
to-
business of the board
That's right.
with a quorum.
That's right.
So we have to
No,
allow
we
public
don't.
comment.
Sue the board.
I promise you that after we pass these bylaws, I will be doing that
I know you
anyways.
will.
But
So
I
you
just
can
want to remind you
include
that there
this
is
in your lawsuit.
pending litigation specifically about violations of the Sunshine
know.
Act.
I
So
know.
I would like to resolve those issues so people don't have to keep suing the board to get us to
Okay.
do our job.
Well,
Do your thing.
I don't know what to
But I mean,
tell you.
wasn't that the whole purpose of us making bylaws, was to be in compliance with the law? So why are we making bylaws that are not compliant with the
What's
law?
not
I
in
just don't
compliance
understand.
with the
The
law?
Sunshine Act, the Title 61
What are you
statute.
referring to that's not in compliance with the law?
Everything in these bylaws that isn't in compliance with the law?
Okay, we're going backwards.
Right,
now.
I
We're
wasn't
into
planning on going
public
backwards
comment.
about this, not going to Manny's comment about public comment in these meetings.
Yes.
I do believe the Sunshine Act is clear
Okay,
that we have to allow
let's
public
not-
comments here.
Rehash that. it's my opinion that we don't have to have public comment at this meeting tonight. I understand you disagree. Why are we going to argue till midnight?
Because you
I don't
asked
want to
me-
argue about it anymore. Let's move on. What else would anybody like to say about this portion of the bylaws?
Sorry, I would just say on 4, comment at meeting no less than 30 minutes, I would just delete that. 3 minutes as usual, but to keep it under 30 minutes, I don't think we should add that one.
Yeah, I agree. And
What did I
again,
say?
again,
Yeah,
I would just
delete.
note that it says
Oh, that's,
that after, you have to have a vote. Okay,
never mind.
that's
Do
okay.
you have more things? Because I have some things. Yeah, can I agree with you going? Okay. I have a couple things. I know that we're in section 13 broadly, but we did kind of skip over subsection A, board participation. And there's a couple things I want to point to in there. So first, I want to talk about in 1, that it says, or other such dates and times as the board shall designate in advance. Who is the board? Like, is that a majority of vote of the board is the only thing that can move meetings from our regular monthly time? Again, I want to point to something that has happened in the past that I think these bylaws are trying to resolve, where one member of the board would unilaterally change the date and time of the meeting without the consent of the rest of the board. So again, when we talked about this previously in our initial draft that I have in front of us, is it talks about how only a majority of the board.
Okay, so how about I say, as the board by majority vote?
As the board by majority vote shall designate in advance. Yeah. Okay. So special meetings are sunshined. That's good. I think maybe we should, look into what that means, a sunshined meeting, and what has to be involved in that meeting. And yeah, I want to clarify, I think that number 5, if we could just clarify what the intention of A5 is, a board member shall not act unilaterally or in concert with another on behalf of the board without authority granted herein or by the governing approval of proper vote and authoritative resolution of the board.
That just means that we act as a whole board, and any action that is taken has to be by proper board vote. That's all it means.
Yeah, but I don't know that that is how this can be interpreted.
Well, how do you think it could be interpreted?
Someone saying that speaking as a member of the jail oversight board and the board could allege that they're speaking on behalf of the whole board. I don't know. I can't think of every single possible scenario. I just don't understand the need for 5, unless someone can point to what specifically it's intended to prevent.
It's intended to prevent, I suppose, somebody directing some action without the whole board agreeing.
But this doesn't say anything about a director directing an action. It says shall not act. So I'm just wondering what that specifically is.
Well, act is also direct. Shall not act. Take action.
But couldn't that say that a board member can't go by themselves to the jail oversight board because they're doing that on behalf of the board and without authority? I'm just saying you could argue.
No, because there's another section that says board members may go to the jail.
Right, I'm just trying to give examples, but I haven't yet received an example of what this is intended to prevent.
Can anybody think of an example? I mean, it's just, you can think of one? Will?
If I'm asked, I will give a.
Go ahead, give one, please.
It's that if a board member who's not a lawyer is interpreting statutory language and representing that interpretation as speaking on behalf of the board, that would be such an act. In addition to which, if said board member in their personal capacity decided to bring a lawsuit against other board members in their individual capacity, but representing in their pleadings that they were standing as a board member, that would also be an act. In addition to which, if a board member brought said personal action against other board members and used that as leverage against the board taking action, that would also be such an act. And that is what that language is intended to provide, is that the board acts as a board in conjunction with Robert's rules, which govern how the board acts, so that there is order to meetings, so that business can be conducted, so that with that business, work is done, that it ends the perpetual cycle that this board has seen historically, years in and years out, where it becomes a cyclical gripe session with nothing being done. So that identifies specifically what that provision addresses. It has to stop. You have to act as a total board and not individually representing that you are speaking on behalf of the board, whether to the public, to the media, or in judicial proceedings.
Oh, yeah, we got to strike number 5 then, because I don't think that my right to sue as an individual member of this board should be restricted by a bylaw. I don't think it can be legally. So I think we just take out 5.
Well, you,
Because
Yeah, I
I've
agree.
basically done every single thing
Wholeheartedly.
Ron just said over there. And I believe that nothing should restrict me from doing that. From filing suit, I never speak as if I speak for the board, but anybody can say, this is how I interpret a statute. Anybody can file suit for any reason at any time. Anybody in their individual capacity as a member of council, as a member of a board, as a member of an executive branch can speak as an individual at any time. So thank you for clarifying the intent of that. I had a feeling that maybe that's what it was about. So can we please strike number
You're
5?
cute by a half.
Yeah.
What you miss
half.
is that you may sue as an individual for anything you want.
Uh-huh.
So please don't misinterpret what I said. Once you, in pleadings, assert that you are bringing a suit as a job member, you have stepped over that bound. That's what that provision is to say. So that because a board member does not get their way on a vote, does not permit that board member to circumvent the board's power to run to the Court of Common Pleas and say, my civil rights were violated because they outvoted me. That's a problem, and that's where you avoid and undermine the board's own power to conduct its own decision-making. Because if someone does not get their way, they would run to the Court of Common Pleas, which is their right as an individual, no question about it. But it raises the issue about the board's power if this board is going to permit individuals to bring suit on behalf of their standing as an individual conjoined with their board power. I say that clearly to the media that's here, to the public that's here. I am not providing a legal answer or advice to this board. I was asked a question based on my knowledge and the fact that I assisted in drafting provisions, as was on my requirement as the executive assistant.
Yeah, I think we should strike
Got
that.
to strike that. I mean, I serve here in my capacity as a county council member. I am the county council president's designee. If I want to sue the board for breaking the law, as I was invited to do earlier, I absolutely can do that in my capacity as a member of the board, in which that is the injury that I have. That is the harm that I have experienced, is that I'm a member of this board. The board violated the law. And I do not think in any way that this needs to be in here, not just for that reason, but for many other reasons. If you want to go out and say you're a member of the Jail Oversight Board, you can do that. If you want to interpret a statute as a person who read a statute online and think it's very clear what that means, you can do that. I think we just take this out. It's unnecessary.
what's
We
everybody's
heard what it meant,
pleasure?
so I think we very much need to take it out. Yeah. Take out 5?
Yeah, I think definitely take it out.
Everybody else?
Okay, cool.
Or nothing burger.
Okay, so we're taking it out? Cool,
Out?
thank you.
Okay.
Okay. Also, I know Executive Inamorano, you brought something up in the past, I think it was you, about where we like house the things. You know how like it's half on the controller's website, half on the court's website? Was that you that brought that up at a meeting?
Of what?
It was kind of like, hey, some of this stuff's on the courts, because I'm just looking at B2 and just like where even the agendas are. And I was just kind of thinking.
I don't think that was me. I think it was just the nature of how it was done in the past, and we just wanted to make sure that where it lives, like if it's on the courts and the controller's website, that it would live in both places. So regardless how people navigated
They'd
to
still
that
get to
information, they'd still get all of the information that they needed.
Okay. And then, sorry, I don't want to dominate. Does anyone else have anything about this section? Because I have a couple more things, but I don't want to like, on public participation under section 13.
Okay, so last meeting, number 10, we're talking about public comments that are submitted electronically. I asked that they be read online. It says that they would be read into the record. Now, these bylaws are saying that they shall not be read aloud in a public meeting. Again, I have to reiterate that, it's important for the public to participate in these meetings. I think they should have been able to give public comment today. I still agree with that, and I think anybody who submits a comment online has every right, has the same rights as everyone else to have their comments read. I think that it encourages public participation, and I think that's what we want. Again, I have to reiterate what we're here for. You know what I'm saying? And most of the time, when the public comes and speaks, it's family members who are speaking on behalf of their incarcerated people, or it's activists. You know what I'm saying? Who are working on behalf of the incarcerated people. So I don't think we should be limiting their comments at all. You know what I mean? I think we should be encouraging them to come and participate or to submit comments online. I understand that it takes a long time. I understand maybe I don't want to be here that long, but I also understand if the jail wasn't as messed up as it is, maybe it wouldn't take that long. Maybe, people wouldn't have so much to say about it. So again, I think we should encourage public participation and not limit it in any way.
Anybody else?
Yeah, I agree very much with everything that Manny said about that. I think we're specifically, I guess, talking about number 5 here. And so one, if someone wants to come to a meeting and sign their friend's name up, they can't speak for them twice if they come, but they should absolutely be able to reserve their time for another speaker. How will you know if someone submits a public comment request sign up online for another speaker? You won't be able to police that. So, and then the second part about a public speaker shall not read a non-present person's comments. We have our meetings on a Thursday at 4 o'clock downtown. It is expensive to park. People work. People are incarcerated and can't get here. People can't find childcare. If someone wants to read a comment for another person, I absolutely think that should be allowed. I think if you want to some way limit that, if that is the intention here, then I think what it should be is each person only gets one public speaking slot. So you choose between, do I want to speak for myself or do I want to speak for somebody else? And like, no offense, John, if he's still in the audience, but can we please do no more of those 15-minute comments?
I think you're right that you can sign up for 3 minutes of public comment as an individual. If you want to read someone else's comments during that time, that's fine. You're just subject to, you can do what you do in that 3 minutes.
Yeah.
Okay, so you want to
Take out
strike
5.
number 5? Well, but you do not, but I just heard that you agree with, you can't assume the time of another person.
You are limited to, public speakers may address the board for up to 3 minutes in 4. You don't get 3 plus 3 plus 3 plus 3. You get 3 total in your public speaking,
Okay,
no matter what.
So therefore, a public speaker shall not have the right to assume the time of another person. That's how 5 should read.
A public,
Speaker shall not have the right to assume the time of another person.
but isn't that kind of saying, that's still saying the same thing, as a public speaker shall not read a non-present person's comments, right?
I'm taking that out.
But I mean, can't we just take out 5 and 4 already says that? You get to address the board for 3 minutes
Okay,
total, and that's
fine.
it. I mean, if I'm wrong, yeah.
We've just seen it in the past, right? Like,
But now.
We've just seen that in the past where, someone said, well, I'm going to give my slot to this individual to give them a total of 15 minutes,
Right.
right?
No.
So we wanted to, just clarify that
That you can't
each
do that.
person gets a 3-minute slot.
I think 4 does say that. Public speakers may address the board for up to, or we could put for a total of 3 minutes.
Well, I don't know why would you object to saying a public speaker shall not have the right to assume the time for another person? It just makes it real clear.
Because that means, for example, I'm a public speaker. I didn't sign up for my own slot. I'm assuming someone else's time.
No, I don't see it. I see it as.
You can't stack
Bethany
your
signed
time.
up, then Sarah signed up, and when I go, oh, I'm going to waive my time, I'm going to give it to Bethany.
Right, but then isn't that already covered by
Then
public
you would
speakers
be
can only speak for 3
assuming,
minutes?
you would be assuming my time slot.
But then you'd be speaking for more than 3 minutes, which 4 does not allow.
Yeah.
I mean,
But that,
it's
that's
not-
been our,
yeah.
that's been our
we've
rules
allowed it.
before, but we allowed it
So
Yeah.
this is
at another meeting because there was not clarity behind it. So we defaulted on the side of giving latitude to the public as opposed to, constraining that. So this just clarifies, so what happened last time cannot happen again.
So what will it say in 5? A public
shall
speaker,
not have the right to assume the time of another person.
And then strike everything else.
can we say to add the time of another person onto their own time?
Fine.
Thank you.
Yeah, I also don't like number 6, when it says all remarks should be made to the board as a body and not to a particular board member. Again, I think that limits a person's ability to speak on what they actually want to say. Yeah, I don't think it's necessary.
Well, the intent of that is that you should not be making a personal attack on a board member. That's basically the intent of that.
But if there are 4 board members who are voting against the thing, I don't need to direct my comment to the full board because 5 of those people are doing the right thing and 4 of those people are not. So if there's one person voting against the thing, I think it's very fair to be able to say they are talking about a subject matter that is appropriate. They should very much be able to say, you 2 didn't vote on this, shame on you, or you should vote on this. I know you spoke out against it in the past, but you should vote for this.
Wouldn't they also just be able to say, the board should do this, or the board should do that? They don't necessarily have to direct it at specific people.
Well,
They should just say, I think the board should do
But
this.
I think
or
they should have the freedom to say what they want to say to who they want to say it. You know what I mean?
Yeah, well,
Yeah. And
Then you
especially, I
should-
think it's
then you
very
should
okay,
vote
again,
however you want.
I keep using the example of county council. People often come and say, so-and-so council member, you are my council rep, I ask that you vote for this.
yeah, well, that's because they elect them.
Right, but they also elected us.
Some of us.
They didn't elect me.
You didn't get elected?
They didn't elect me to
didn't
this
elect
job,
anybody
no,
to
not to
this
this
board.
job.
But,
No.
To this board.
but
No,
you,
not to this board.
but the county executive, the controller, the sheriff were elected for roles that came with a seat on this
Right, but
board.
not to this board.
But they were.
Same, but yeah, this is a different, you realize that this
They're
is
ex officio
different.
members.
Yeah, but this is different.
Ms. Inamorado,
With number 6, I feel fine if we strike the all remarks should be made to the board as a body and not to a particular board member. I feel fine with striking that. I would ask that we leave the first part of subsection 6, which says public comment shall be limited to matters within the jurisdiction of the board. I say that because my job touches many things. I don't want someone to come into this board meeting and start talking to me about the health
Reassessments.
department or reassessments or
Yeah, that's
whatever,
fair.
right?
Okay.
So that's where I see protecting the time of this board.
okay, anything else?
No speakers shall. Oh, yeah, I do think specifically, I get vulgar language. What is vulgar? What is offensive? What are slanderous remarks? I very much think refuse to leave the podium after allotted time is a fair thing to have in there. But I just want to know, like, who is determining what is offensive and what is slanderous? I think those are super
I
vague
think
terms.
Common sense, everybody knows that if somebody comes up and it's offensive and vulgar, I think that the chair can determine what is disruptive and vulgar and offensive.
Okay, then can we take out make slanderous remarks? If it's offensive and vulgar, I think that covers what slanderous remarks is attempting to cover.
I
Yeah.
take out slanderous. I think it's a legal term that, yeah.
Okay. So leave the rest and put take out make slanderous remarks.
Where is
I'm on,
It's on the last sentence
No.
on page 10.
no,
Oh, sorry.
backwards. One more. Yeah. Where are we? Here. Use vulgar, make slanderous remarks. Take it out.
We gotta move this along. Oh my God.
I know. Okay, anything else?
Yeah, I kind of want to jump back to number 4. I know we spoke about it a little bit, but I really don't understand. I know it says the board, after majority vote, may limit the total testimony of public comment at a meeting to no less than 30 minutes. Does that mean only 10 people can speak?
Good question.
Yes, and it would require a majority vote in order to do that at any particular meeting.
So I kind of have a poor memory. So before we came here today, I went back and I watched the previous meeting, and this was specifically brought up, and we agreed not to put it in there. That's why I take issue with Crum not only participating in what's happening now, but also not including our input in this draft. We agreed, all of us agreed at the last meeting, not to limit public comment. I don't understand why we keep trying to disenfranchise the public.
This is only if we voted that there was a specific time on a specific meeting, if we needed to get to something, that on that specific day, that we would limit it. It would require the majority of the board to vote on that day, like say that somebody had to get to something. It wouldn't mean that this was done like as a blanket rule. I get it. It's not like, it was, I think it's just there in case that there was some date on a specific date that the board needed to do that. And again, it would require a majority vote. I would imagine that most times the board is not going to do that.
Right, I don't think the board should do it at all, at any
but-
time.
So then they probably never will, but it's there in case we would ever need, under some circumstance, for some specific meeting, to basically lighten the load that day.
But can,
I think we're putting.
But the load you're talking about are like actually people, and I think it's important for the voices to be heard.
I totally understand that. I'm just saying, can't you envision at some point there might be some time where we actually might need to get to work and have it in there just in case? Just in case.
No, I don't think we should have it in there. I think
Okay,
this
well
is
then
the
don't
work.
vote for it. I know, I get it, but I'm just saying.
I won't vote for it. I don't think it should be in here. And then not only that, when we talked about this at the last meeting, we agreed not even to put it in the draft.
We did.
All right, so that's why I'm a little frustrated because, like Bethany said, all the work that we have been doing on this, on this for months, it seems to have been, forgotten about or not taken into
There's
account.
a lot of things that I'm not, I get it, but I get that there are also times when there's things and things that you put in there that you might never want or need, but you have them there, again, just in case. I just
All right, but
figure
this-
like it's
this-
there
this-
just in case.
but this
Okay,
thing
what's
specifically we
everybody's
agreed not to
pleasure?
put
What's
in.
everybody's
again,
pleasure?
I think the first question is though, is what changed? We all agreed at the last meeting. That's the part I really want to
Okay,
focus on
maybe
what
it
he's
was a
saying.
mistake. Not everybody's perfect, okay? Maybe Crum made a mistake. Maybe he didn't maybe he didn't even have the transcript. I'm sure he didn't.
I don't know.
He was there.
Does everybody, maybe he forgets.
I'm
Okay,
sorry. I was
everybody's
in
not
the- I was
perfect.
in the men's room.
I don't know where.
That you were accused of intentionally putting something in here that everybody wanted out.
Categorically deny such.
Okay,
That's what happened. That's what happened. That's exactly what happened. We can read the transcripts
okay,
if you want.
excuse me, Manny. I take issue with you accusing someone of intentionally doing something to undermine somebody. You have no idea what his intent was, and I don't think that's proper.
You're
okay?
right. I don't know what his intent was,
Right,
but I
so
do
please
know.
don't make an accusation, and please don't interrupt me, okay? Who
I
wants
do know
it
that we
out?
agreed. not to
Excuse me,
put
you
it
want
in
it
there,
in
and
or
it's in there
out?
now.
I'm not done with discussion yet.
Out, and we can make a motion.
You could take it out. If there's an emergency, you can make a motion at that time, but delete it.
Fine, it's out.
Yeah.
All right, anything else on these?
It's 5 o'clock. so-
Public comments shall be reviewed by the. Oh, so the only thing I will say is for number 10 here, is there going to be, so how are we going to distinguish between the people who are like signing up to comment versus the people who are actually like submitting online public comments? That's my only worry with 10 because it said, you know, electronically submitted public comments will be included in the record.
There'll be a sign-in sheet. Is that what you mean, for people who sign up to speak?
I guess I more mean when I'm a public commenter and I'm going online to sign up for public comment. How do we distinguish between I'm signing up because I want this comment written and in the record, and I'm signing up because I want to give this comment in person?
Well, there'll be a sign-up sheet to speak. I'm assuming that IT can do this, okay?
Okay, yeah.
Because it's on the court to do it. I assume they can do it.
Uh-huh.
Right now, people can submit a comment.
Mm-hmm.
Okay, we've all seen them. There's going to be a separate sign up to speak.
Mm-hmm.
So it'll be 2 separate buttons that you click.
Sign up to speak versus sign up for public comment online.
Submit a public
Right.
comment and sign up to speak. It'll be 2 separate things.
Okay, so we're going to be adding an
We're
option.
going to be adding an
Okay.
option, yes.
Okay, and then I'm cool with B, but I'm ready to move to C if everyone else is.
Go ahead.
Okay, C specifically, okay, number 1, cool with. Number 2, cool with, although I think it's redundant, we've said that multiple times. Under A subsection 8, we say the meetings of the board shall be otherwise conducted in accordance with Robert's Rules of Order. And then under C2, we say Robert's Rules of Order shall serve as the determinant of proper decorum. That's my only thing with that is it's repetitive if you feel the need to keep it both for, you know, the meetings and the decorum. I'm not going to fight about that. I do have serious issues with number 4 and number 5 and number 6. Again, I will go in order about those. So number 4 is you cannot give superfluous commentary, inflammatory remarks, profanity, or other disrespectful or undignified behavior. Profanity, I think, is cool. I think we all know, I know not to do that anymore. But superfluous commentary and inflammatory remarks, I think, is very ambiguous and subject to interpretation. Who is the person determining that?
I'll determine it when
Excuse me, Mr. Crum.
I am out.
Please.
You're right.
You are out of order.
Someone did not defame me on the record.
No one defamed you on the record, and it wasn't me, so that's funny that you're directing your comments towards me
Okay,
right now.
let's
I'm
calm
directing
down.
it to
We
the
would
board.
let no one else in this audience act the way that Mr. Crum has
Okay,
been
stop
acting.
talking, please, Mr. Crum.
The next
Okay.
thing is board members shall refrain from personal attacks, derogatory name calling. I am cool with those too. I will say I'm not fighting against, personal attacks and derogatory name calling, but impugning the motives of others is the one that I have issues with and being ambiguous. For example, if I want to say that, I'm trying to think of an example that would never be real. But if I want to say that I question someone's motives on something, I think that I should very much be allowed to say that, especially if evidence points to that or past practice points to that or their own words point to that. So I would like to take out impugning the motives of others. And I would like to take out superfluous commentary and inflammatory remarks from number 4.
Anybody disagree with taking those out? Fine, they're out.
Okay, impugning the motives of others. And then on the back, I'm worried about number 6, especially if we are, it's seemingly going towards an unelected chair. If the chairperson can make someone just shut up, basically, when we're talking about something until the issue's done, I'm pretty sure that's going to be
Well,
used.
it says until the question of order is resolved. That's That's Robert's Rules of Order, I believe.
Okay, so that is saying what? Tell me like what that looks like.
Go ahead.
I would say an example of the way that this meeting has been run, where we're talking over each other, we should all have to signal to whoever the chairperson is that we would like to speak, and then they would acknowledge us, and we would speak. If we have members who are speaking over one another, then we would call for order, and then we could continue to go based on who's called on and whose time is allowed to be, who's currently speaking, right? To me, that's how that works.
Okay. I understand that. Like, hey, well, this is a working session, so I guess it's a little different because we are kind of talking over each other. But you mean like how in the meeting, nobody goes and starts asking questions until I say I want to talk?
Yes, yes.
Yeah. I don't love it, but okay. I'll move on to 7. I very much agree with conflicts of interest. You know, if someone, has stock in GTL, you should probably tell us before we vote on a tablet, having GTL tablets in the jail. My biggest issue is the board member being disqualified from further participation in the pending subject matter. I do not think we can limit a board member's participation in this board who is either, duly appointed or duly elected in a role that has a seat on this board. So I would just say, end it after resolution.
Well, it says in the pending subject matter. So if you have a conflict of interest, you should be disqualified.
Well, then you should abstain. You can't, like, for example, on council, you have to abstain from something you have a conflict of interest on, but I can't say, hey, you can't vote on this. If they do, with a conflict of interest, then they are subject to ethical remedies, but we can't stop them from voting and participating in a conversation. So I think that I would be cool with it ended after determination by board resolution.
I don't care. What's
That's
everybody
fine. I
say?
think we just gave out an example of what that means.
Judge, where it says that we're bound by codes of conduct and ethical standards, like, what are those standards?
I have no idea.
I know all about the law. No, but really. So the county has an ACE commission, but I think this is just including all board members in that commission now, under the purview of the Allegheny County Ethics Commission. That's how I interpret this to read. I am already bound by it. The judges have their own judicial ethics commission, the Judicial Conduct Board, the exec and the controller and the sheriff would all be under that. My interpretation of this is it brings the community members of this board under that standard,
Okay.
Unless somebody wants to say otherwise.
No, there's a form in most boards, you have to fill it out. I mean, we do as electeds, but yeah, that's probably something that the executive just mentioned that we probably should do that anyways. It's a simple form, everybody gets it every year, yeah.
Okay.
Okay. I hate to say that it's 5 o'clock.
Can we schedule our next one of these, though? Because we didn't get to anything else on the agenda, and there was a lot of stuff.
Sure.
Is everyone cool with that before we bolt out? Corey, before you leave, can we please pick another date? Can we pick the date for the next one? Oh, I think we should never stop doing this. This is great. This is the only time we get stuff done. Judge?
Well, there's an issue with the controller's office paying for the videotaping and the
I'm
transcripts.
trying to think what we didn't get to that a committee.
We didn't get to anything else on the agenda but the bylaws. So every other thing, we didn't talk about worker pay, we didn't get an update on the uniforms. We didn't
Well,
talk
maybe we
about,
should just put this on the agenda at our regular meeting,
put what?
the rest of these items.
I don't know that there are voting actions.
Oh, yeah.
But, I mean, but we
The
could
working pay is,
discuss-
the worker
We
pay
can
is.
discuss these, we're allowed to discuss
Oh,
these
yeah, yeah,
issues
yeah.
at our next meeting.
Okay, I'm cool with
But
that.
let me
but-
just tell you, the issue is though paying for the videotaping and the transcripts. Okay, because the controller budgeted 12 of these, we've already had 2 extra ones. So that's gonna be a
So
problem.
we budgeted for the 12 meetings, so that these are 2 extra ones. So if we do more,
How much does it cost?
how
ish, like $1,000 or like 500?
Encore knows.
It's not that much.
How much?
Guys,
It's some, it varies depending on the duration of the meeting, so I can never tell
we'll get numbers.
Because remember, we do have the Incarcerated Individuals Welfare Fund. I would say that if we have to in the interim, I would work with county council to fund it for like maybe the next year. But we do have the Incarcerated Individuals Welfare Fund at our discretion if we need to dip into that to offset the controller's expenditures.
Yeah, we
Does
can,
anyone need a snack?
I'll find a number.
Yeah, can I have Doritos? Do I get to pick? Is there like a certain different, thank you, Larry. Thank you.
You're welcome.
Tell them to call